Hi, I'm Mark Nordenberg, the former chancellor of the University of Pittsburgh. I currently serve as both the chair of Pitt's Institute of Politics and director of its Dick Thornburgh Forum for Law and Public Policy. It is the Institute and the Thornburgh Forum that are sponsoring this Governance in Crisis series. And on their behalf, I extend a welcome to each of you. It is a particular pleasure to be able to welcome Chuck Rosenberg to our series. I say that because I have been a long time and very strong admirer of Mr. Rosenberg, who I consider to be one of the country's truly outstanding legal analysts, someone who is always calm and clear and convincing. Building on his extraordinary career in federal law enforcement, Chuck has become a widely respected commentator on legal issues generally and on issues relating to federal law enforcement in particular. He joined the Justice Department through the Attorney General's Honors Program right out of law school and went on to hold an amazing succession of very important positions in both Republican and Democratic administrations. These include acting administrator of the Drug Enforcement Administration, chief of staff and senior counsel to the FBI director, U.S. attorney for the Eastern District of Virginia, U.S. Attorney for the Southern District of Texas, counsel to the FBI Director, counselor to the Attorney General, and Chief of Staff to the Deputy Attorney General. Chuck currently is a senior counsel and member of the White Collar and Regulatory Enforcement Group at the Crowell and Mooring law firm in Washington, D.C. He regularly appears as an analyst and commentator on NBC and MSNBC. He also writes regularly on legal issues and is the host of a very popular podcast called The Oath. How popular, you might ask? All I can say is that it has more than 9 million downloads and has a perfect rating of 5 stars out of 5. Chuck, I've already made reference to 7 or 8 important positions that you have held. I would consider them all to be important. I guess you started as what the current Attorney General would call the lowest level line prosecutor and went on to political appointments such as the leader of the DEA and the U.S. attorney in 2 judicial districts. To play off the title of your podcast, for how many of those positions were you expected to take an oath?
Every single one of them, Mark. I think I've taken the oath 9 or 10 times, and it is always a privilege. It reminds you of what you're doing and why you're doing it. I should also add, based on your introduction, I think your viewers can now tell I cannot keep a job. I've been incredibly privileged in my Justice Department career to have lots of different ones. But the thing they all have in common, of course, is that it was all part of the Justice Department, a place that I love, and I was incredibly fortunate to be a small part of it for some number of years.
And when you take the oath, just to make this more real, what do you actually do? Is there someone there administering it, or is it something that you complete on paper, or how does that work?
Well, both. You actually sign an oath, and then typically there's someone there who administers it as well. So you put your right hand in the air and you repeat the words of the oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, and to bear true faith and allegiance to the same. That's not all of it, but that's certainly an important part of it. And by the way, I should add, as U.S. Attorney and as the head of the DEA, I also administered the oath to hundreds and hundreds of people. And it's an incredibly moving ceremony because you recognize in the oath that we are not pledging allegiance to a political party or to a president or to a person, but to the Constitution. And that's sort of at the heart of it, what the oath is about and why it matters so much, that our allegiance is to the Constitution and to the country, regardless of who is in charge of it.
Well, I think this is very interesting in two different ways. One is the way you said it made you feel, whether you were taking the oath or administering the oath, because I do think that people who go into government service most often are motivated by a desire to serve the greater good. And would be inspired by the oath, and I'm not sure that gets underscored as often as it should.
No, that's a great point, Mark. And it may sound corny, but right, we're not doing it for the money, obviously, and we're not doing it for the prestige. We're doing it because we believe in something greater than ourselves, right? A collective, of a sense of responsibility, of service, of devotion or dedication to our country, to our community, to our colleagues, to fellow citizens. And so it's interesting. Whenever I interview somebody on my podcast, The Oath, I almost inevitably ask them, do you remember the first time you took it? And every single time, not only do they remember it, but they remember all the details, where it was done, who administered it, who else was with them. Sometimes it's a family event and people would invite a spouse and children to attend. But everyone remembers it, as do I.
And certainly that is true when you are formally installed to a position like the United States Attorney, which would be a big moment in anyone's life.
Well, we actually did it twice then. Once immediately in a judge's chambers, so I could, assume the role, the position, and carry out my duties, and then later in a sort of a ceremonial setting. But you actually have to take the oath in order to start the job. And so rather than wait for the ceremony, I went with a buddy of mine to the judge's chambers and swore out the oath in front of the judge.
Well, the other very important thing you said and you emphasized is that the oath is an oath to the Constitution, which is the supreme law of the land. So it really is an oath to the country. Is that like taking an oath to the rule of law, to maintain the rule of law?
Well, I think it's analogous. We don't use that phrase in the oath. By the way, the words of the oath actually come from federal statute. So if any of your viewers want to go read it, Title V of United States Code, Section 3331, if I recall. But it very much gets at that notion, Mark, that what we are swearing to do in supporting and defending the Constitution is abiding the Constitution, right? Is following all those rules and regulations and laws that, sort of form the fabric of the justice system in our country. And by the way, not just the rules and regulations and laws, but also the norms, the ethos of our offices and of our missions and of what we are supposed to do. Because between the lines of the rules and the laws and the regulations are those norms. And that is such an important part, I think, of what we do as prosecutors and agents at the Justice Department.
Well, and you are a real lawyer, and I at least was trained in the law and taught the law. And I think that people with our backgrounds do use the term rule of law in an almost automatic way. I'm not sure everyone understands quite what it means or why it's so important to us. Can you talk about that a little?
Well, first of all, Mark, it's debatable whether I'm a real attorney. I was a prosecutor, which means I have a narrow set of skills, but whether or not I'm a real lawyer is a completely different question. But I think of the rule of the law really as a construct. And by that, I mean, the law of gravity is a constant. If you were to drop a pencil anywhere on this planet, it would fall to the ground. And that would also be true in places that don't have the rule of law. So if you were in a country, for instance, with no functioning rule of law, no functioning justice system, the law of gravity would still pertain, right? But that's not true of the rule of law. It's a construct. It's something that men and women have designed, that they built, and that they nurture. And so while it sort of summarizes how we think about what it is we do, it's incredibly fragile, because those same people who built it and nurture it could also destroy it if we're not exceedingly careful. So that may be a bit of an abstract answer. I don't know if it answers your question, but what I wanted to convey is how precious it is and how fragile it is.
The Attorney General recently participated in a Constitution Day program at Hillsdale College and gave a speech which, for a range of reasons, has attracted a lot of attention. He made some statements in that speech, though, that I think bear directly on what we're discussing now. So let me just quote a couple of them to you. First, he said the rule of law is the linchpin of American freedom. And he said the essence of the rule of law is that whatever rule you apply in one case must be the same rule you would apply to similar cases. And you and I would agree with those statements, wouldn't we?
Completely.
And then he did go on to make a related statement, I think related in particular to that second point, in saying that the criminalization of politics is not healthy. That might seem to be a stunning statement coming from an attorney general who serves a president who was elected by leading crowds in chants of "lock her up," referring to his political opponent. And I don't know whether the use of those words was part of a larger effort to elevate the rule of law within the administration or not. Do you have thoughts about whether or not those words have kind of governed the behavior of the Attorney General?
Yeah, what I've seen in this administration, and by the way, I've served under attorneys general and presidents of both parties. I consider myself a raging moderate. I was honored to be appointed to one position by President Bush and one by President Obama. So what I'm about to say, I don't mean in a partisan way at all, Mark, but the politicization of law enforcement in this administration has stunned me and saddened me. And it's unlike anything I've ever seen before. Now, that's not to say we're perfect, or I've never seen instances of it. But in the past, when I've seen instances of it, it was the exception and never the rule. And it seems to me today to be the rule. So not just the lock her up chants that the president led, which seem unfathomable to me from any other president that I've ever seen or heard or watched, but also this notion that there's a list of political enemies. It makes you think of Nixon, and that we're going to go get them. And the president has expressed his desire that Hillary Clinton go to jail or Jim Comey go to jail. Things that we just don't do in this country. I mean, if they broke the law, that's one thing. But the president calling for the imprisonment of political rivals is deeply dangerous. His use of pardons to reward friends and allies is deeply dangerous. Pardons have been improvidently granted in the past. I can think of one that Bill Clinton gave at the very end of his tenure that was deeply troubling. But this president has routinely used it to reward friends and allies. And other examples, Mark, perhaps that you want to get to later, but I can mention now, the intervention by the Attorney General of the United States on behalf of friends and allies of the president in pending criminal matters, like Roger Stone and Michael Flynn. And so again and again, his rhetoric, which in some parts in the Hillsdale speech made a lot of sense to me, diverges wildly from his practices.
The framework really does make sense. And then it's the application of it or the observance or lack of observance of it that seems to create problems. And there are two sides of it, I think. One is he talked about the criminalization of politics being unhealthy. And you talked about the politicization of criminal law as being unhealthy, and it seems to work both ways. So let's go back to the one example in particular that you mentioned, and that is the intervention in the cases of Michael Flynn and Roger Stone. Why is that inappropriate?
Well, so let me set it up with some context first. The Attorney General is the head of the Justice Department, and all the authority of the Justice Department is vested in the Attorney General. That's true by statute, Title 28 of the United States Code, Section 509. You can read it for yourself. That said, the Attorney General is also a political actor. He's a member of the President's cabinet, and there are perfectly appropriate political tasks for an Attorney General, for instance, in the selection of federal judges, or perhaps in promulgation of policy. But the one place where an Attorney General can never transgress is in the law enforcement, where a president can never transgress is in the enforcement of criminal law in the United States. And so we know that this president has strong feelings about the prosecutions of Michael Flynn and Roger Stone, and that's precisely where we've seen the Attorney General intervene. The Michael Flynn case, I think, is a great and dramatic and sad example. Here's a man who pled guilty twice in front of two different federal judges in federal court to lying to the FBI about material matters involving his conversations with the Soviet ambassador to the United States, Sergei Kislyak. For some crazy reason, and that's the best word I can think to describe this, Mark, is crazy, the Attorney General sort of came up with this theory that General Flynn's lies were not material, and then intervened in federal court on the defendant's behalf, on Flynn's behalf, to have the case dismissed. It was so jarring, it was so unusual, and it was so improper that prosecutors, line prosecutors, career prosecutors associated with the case resigned from the case. And you don't see that, right? I mean, that's not how we do our work as career federal prosecutors. We understand that we have political superiors. We understand that our views may diverge from theirs. We understand that when our views do diverge from theirs, they have the final say. But I have never seen it improperly exercised. And so when the president, through his Attorney General, intervenes on behalf of Michael Flynn or Roger Stone to lower his second sentencing recommendation, it's those types of political interventions in the criminal enforcement mechanisms of the United States that cause prosecutors around the country to just sort of gasp, because that is not the type of thing that we see. And when we do see it, it is deeply, deeply disturbing.
And in that case, there is intervention, basically using the law as a shield for the two gentlemen that we were discussing. Now, there also was a recent resignation of a career prosecutor in the investigation that is being led by the U.S. Attorney from Connecticut at the request of the Attorney General. Can you talk a little bit about that?
Sure, and some context. So the U.S. Attorney in Connecticut is John Durham. He's been in the department for a long time. I know John, and he has a wonderful reputation. He was asked to investigate the origins of the FBI's counterintelligence investigation into Russian interference in the 2016 election. John's top deputy, a woman named Nora Danahy, also a longtime, highly respected career prosecutor, recently resigned from the Durham task force, for lack of a better word. She was reportedly, according to the Hartford Courant, disturbed by political pressure being brought to bear on their work, and I can assume on the timing of their work, because Mr. Barr has said he would like the Durham report, his findings, out before the election. Can I add some more context here, Mark? And if I'm blathering too much, just tell me to stop. But there is a long-standing policy in the Department of Justice that we, as federal prosecutors, take no overt investigative steps intending to affect the outcome of an election. Now, that has been construed as a 60-day rule or a 90-day rule. Actually, there is no number attached to it. When I was a prosecutor, I just thought it meant after Labor Day in an election year, which is roughly a 60-day rule. But the rule is that you don't interfere in an election, and we all know that. And so by its very terms, and this goes back to something I said earlier about norms as opposed to rules and regulations, by its very terms, if Durham is not charging Donald Trump or Joe Biden with a crime, he fits within the definition of the policy because he's not interfering in an election, right? Construed narrowly, it would mean you don't charge a candidate in the run-up to an election. But there are also norms at work, which means more generally, as you step back from the policy, you don't do anything to interfere. And you don't read the policy narrowly, you read it broadly, and you read between the lines, which includes not taking any step that would interfere in an election, including, in my view, the release of a report favorable to the president, timed in advance, a few weeks perhaps, of our November presidential election. And that's what I mean by norms, right? In the abstract, it can sound a bit confusing, but when you sort of drill down on it, we know how to behave, right? And so it's not just the written words of our election policy. We don't do anything to try and tilt the playing field in favor of one candidate or another. And that, in my view, would include not releasing a report politically favorable to the president in advance of an election.
And in this case, it seems to be a case in which there actually is a race to get this done so that it can be released prior to the election.
That's right, Mark. And that is reportedly what troubled Nora Danahy. Now, I don't want to speak for Nora, and Nora has chosen not to speak about it, which I admire and respect. But the Hartford Courant ran a story in which it seemed to have spoken to people close to her, and they reported that that was apparently her concern. We'll see. Maybe at some point she'll tell us herself. But I can tell you this. Federal prosecutors and federal agents, whether they're FBI or DEA or ATF, what have you, don't leave big cases in the middle unless there's something desperately wrong. Now, maybe it's a personal issue, and if it is, it's none of our damn business. But if it has to do with political pressure being brought to bear on the team to produce a report by a certain date so it can be weaponized in a political race, that's a big problem. And so while I like and trust John Durham, it's not John that concerns me so much, Mark. It's what the Attorney General and the President may do with his work. And I think there's a really good analogy for that, if you want to get into it, the Mueller report.
Yeah, I was going to take you back to the Mueller report in any event, so why don't you talk about that analogy?
Sure. So whenever I'm biased, I like to tell people I'm biased. I work for Bob Mueller. I think the world of Bob Mueller. I would walk barefoot on broken glass for Bob Mueller. I often tell people that working for him often felt that way. But he is an American hero, an American icon, a Marine officer who served in Vietnam 12 years as FBI director, former federal prosecutor, a man of tremendous integrity and dignity. His team, when he led the special counsel's office, produced a 448-page report. Volume 1 focused on Russian interference in our 2016 election, something about which there is unanimity in the intelligence community. About what the Russians did and why they did it. Volume 2 was about obstruction of justice. And in it, the Mueller team outlined 10 steps that the president took to interfere, to obstruct the Mueller team's investigation of what happened. And it's really pretty dramatic. I don't expect anyone to run out and read a 448-page report. I've read it twice, but you can at least read the executive summary. It's very disturbing. But when that report was released, it was first released by the Mueller team to the Attorney General, who then I saw mischaracterized its contents, basically sort of twisted what the Mueller team found, downplayed their findings, said essentially that they weren't making any, sort of criminal allegation, and that, we should all just essentially move on. That completely missed the point, particularly of Volume 2, Mark, the obstruction section of the report. What the Mueller team said was that there's an existing Department of Justice policy. It was promulgated first under Richard Nixon, and it was promulgated again under Bill Clinton. So a Republican and a Democratic president, which said that you can't charge a sitting president with a crime while that person is in office. And what the Mueller team said was, because of that policy, we're not going to make a recommendation. We think that would be unfair. If you can't charge a sitting president, nor should you recommend a charge against a sitting president. And you can see the Mueller team just played it straight down the middle. They were beyond fair. They were remarkably restrained in how they wrote their report and what they recommended to the Attorney General. But the Attorney General twisted it to say that they didn't make any such finding. Technically true, but true because they were constrained by Department of Justice policy. If you actually read the report, and again, I understand folks don't want to read 448 pages, but if you read the executive summary, you'll see a stunning pattern of obstructive behavior by the President of the United States. I've said on television, and I'll say again for this forum, if anybody else did what the President allegedly did, as outlined by the Mueller team, they would be charged, they would be convicted, and they would be incarcerated.
That's a strong statement. Let's fast forward to some uses of the law that are more current. The first involves the report that the Attorney General had discussed bringing sedition charges against both protesters, rioters, I probably should say more accurately, and about the elected officials in some of the cities where the riots were taking place. I'd never heard of anything like that. What's your thought?
Yeah, so this one gets a little bit more complex. So again, I'll throw another statute at you. 18 U.S.C. 2384 is the sedition statute. And when we think about sedition, we often think of a conspiracy to overthrow the government of the United States. Actually, you can commit sedition in several different ways, and the most dramatic of them is to overthrow the United States government. But if you read the entire statute, also forcibly seizing property of the United States or hindering law enforcement can be types of sedition chargeable under that statute. And so I think immediately everyone raced to the conclusion that the Attorney General was arguing that these protesters were trying to overthrow the United States government and that bringing a sedition charge would be utterly insane. I also want to be fair to the Attorney General because the sedition charge can be read in different ways. There are different ways to violate it, and there are less serious ways to violate it. So if he's only talking about the seizure of federal property, which seems like a strange way to think about sedition, but is nevertheless in the statute, you could have that charge under certain circumstances. Have U.S. attorneys around the country ever brought sedition charges? Yeah, rarely, but we have. And have they ever been based on conspiracies to overthrow the United States government? Again, occasionally, but rarely. But they've also been predicated on those other ways that you can violate the statute. And so I think this is a place where the Attorney General's intent wasn't very well explained or very well described. And I think because he has lost the confidence of so many people, commentators immediately raced to the worst possible construction of what he said. So while I am not a fan and I have been a severe critic of him, I also think it's important to be fair when there's another explanation that could lie.
What about the use of that criminal statute against the elected leaders in those communities?
Yeah, that seems to me, Mark, to be utterly bizarre. Now, I don't know that he necessarily said that. I mean, I know that the president and the attorney general have talked about anarchist cities, which is troubling to me in its own right. Look, if a mayor of a city has violated the sedition statute, well, then, so be it. Then we ought to bring charges. But I haven't seen anything approaching that sort of behavior from our elected leaders in those cities. I want to be very clear about that. I think it would be wildly inappropriate, based on what I've seen and what I know, for anybody to just suggest, for instance, that the mayor of Seattle has committed sedition. That strikes me as nuts, which I know isn't a technical legal word, but sort of conveys how I feel about it. But, so the Attorney General, I think, has squandered a lot of his goodwill. And I also hate this notion that we talk about America as, red versus blue, or cities versus, rural areas. I mean, we're all Americans. There are people who live in blue states who voted for Mr. Trump. There's people who live in red states who didn't. And the way that the president in particular has divided us, it strikes me as both sad and dangerous. We're all Americans, for God's sake, and we ought to find some common ground and pull together.
So let me just go back quickly to the last example and the most recent example you touched on, the declaration that New York City, Seattle, and Portland were anarchist cities, a declaration that I think did come out of the Department of Justice and was intended to put some funding at risk. Again, I'd never heard of anything like that.
Nor have I, Mark. I don't remember ever hearing anything like that. Look, it seems to me, and I hate to be so cynical, that it was designed for political purposes. That these are blue cities in blue states, and that the president has decided that they don't matter, nor do their residents. And if that's what's going on, and it seems to be, that's very troubling.
I'd like to talk to you, if I can, about two structural issues. The second we've already talked about a little bit, but you have said on some occasions that the flatness of the organizational structure within the Department of Justice is one of the guards against political interference. Can you talk about that a bit?
Yeah, I think the way I described it, so the organizations are somewhat flat, but the point I had tried to make, and maybe inartfully, was that they had very thin political layers. So for instance, the FBI has 37,000 employees, about a third of whom, roughly speaking, are special agents. The rest are analysts and professional staff and occupy a whole bunch of different and important roles. And then I would always ask people, Mark, of those 37,000 employees at the FBI, how many do you think are politically appointed? And how many do you think are career civil servants? And people would always sort of stumble with that answer. And understandably so, they didn't work there, they don't know, that the answer is one. Of the 37,000 employees at the FBI, one of them is politically appointed, the director. And when I was United States Attorney, for instance, in the Eastern District of Virginia, which was a great privilege, I had about 220 colleagues in 4 offices in Norfolk, Newport News, Richmond, and Alexandria with whom I worked. I was the only political appointee. And so by design, it's not the flatness as much as it is the fact that there's an incredibly thin political layer. Go back to what the Attorney General said when he spoke to folks at Hillsdale College. He bemoaned the notion that career men and women in the Department of Justice were acting as preschoolers. And he said, only those of us who are politically appointed are accountable. And therefore we run the department, and essentially to heck with everyone else. It's actually exactly inverted. The strength of the Department of Justice is that you have folks who have given their professional lives to that institution, who understand and apply the rule of law, who are consistent and apolitical. And that's where the most important decisions get made. Of course, as I said earlier, if there's a difference, right, the political boss gets to decide, but it should never be for an improper or political reason. And so the strength of the Department of Justice, whether it's the FBI or the DEA or the US attorney community, is in that incredibly thin political layer, and in the fact that you have this broad base of career professionals who are looking after the institution.
And there is, to be clear, supervision within the Department of Justice, even if the politically appointed leaders are not involved.
Absolutely. And when I was a brand new baby prosecutor, I mean, I had a unit chief, I had a criminal chief, there was a first assistant U.S. attorney I could go to my more experienced colleagues. I actually held some of those positions within the U.S. Attorney's Office. So still as a career prosecutor, I also served as a supervisor as I got more experienced. And that's where you learn how to be a prosecutor. It's not from memos from the Attorney General, the Deputy Attorney General. It's from the men and women in your hallway to the left and right. And I don't mean politically, I mean physically. If you had a question, you just walk out your door and you walk into someone else's office. And you can talk about, strategy or tactics or the rules of evidence or whatever you needed to do. And there's this incredible reservoir of knowledge and information and experience at your disposal. And that is the strength of the Department of Justice. Look, we're not perfect. We make mistakes. I've made plenty in my professional career, but we try really, really hard to get it right. And again, I can't say this enough, so I'll say it again. That is the strength of the department. It's the career ranks, and it is designed that way on purpose.
The other structural issue that you have touched upon is the relationship between the president and the attorney general, where, as you indicated, the attorney general is a part of the cabinet. Mm-hmm. There are certain things in which he may rightfully be involved that are political, but others where you're crossing a line. And I think this is important enough that I'd ask you if you could talk about that again.
Oh, sure. And I probably didn't do a very good job earlier, so my apologies. But you're right, Mark, you're exactly right. The Attorney General is a member of the President's cabinet and has both a political role and an apolitical role. The political role, for instance, in promulgating policy or perhaps even making grants or perhaps in selection of judges. That's fine. We all get that. And so the Attorney General can sometimes have a very difficult line to walk. But where an Attorney General can never act in a political way is with the criminal enforcement mechanisms of the United States. That doesn't mean he or she can't decide that a thing ought to be charged or not charged or charged in a certain way. I don't mean that at all. The Attorney General, in the end, has to make those decisions because he or she is responsible for the operation of the department. You just can't introduce politics into that equation. And so when the President of the United States tweets, and I'm told he occasionally tweets, I'm not on Twitter, I don't have any social media accounts, and I plan to never have one as long as I live. But when the President tweets about how a certain case ought to be handled to benefit, let's say, Roger Stone or Michael Flynn, and then the Department of Justice takes that position at the direction of the Attorney General, right? That's the problem. That is the problem. And it's the Attorney General taking that political role, appropriate in some circumstances, and using it in a way that's completely inappropriate when we're talking about the enforcement of federal criminal law.
And taking that in another direction, on the other hand, for the Attorney General to be involved in policy making or being supportive of legislation in criminal justice reform or criminal justice crackdowns, anything like that would be appropriate.
Completely, right. I mean, in fact, you would expect the Attorney General to have a role in, so the President makes lots of policies in lots of different places, not just President Trump, President Obama, President Bush, President Clinton, President Carter, they all do. And there are certain things they want to convey. There's certain things they hope Congress will do. There's things they want funding for. Of course, you would turn to your Attorney General, for instance, on sentencing reform or criminal justice policy, a completely appropriate role of the Attorney General of the United States. So I agree with you on that. But you have to be really careful when you're talking, again, about enforcement of federal criminal law, because if that becomes politicized, if we become that country, and we've seen it elsewhere in the world, where those in power prosecute those out of power, and then it flips, all is lost, Mark. That would be a horrifically bad outcome. We can never be that country. And I fear, and I tend to be an optimist, but I fear we're drifting in that direction.
One of the things that we have seen in recent years is people who seem to be subjected to competing pressures. They're in positions that are important. They like the work they're doing. They think they're making a contribution. But there come to be these collisions between what they consider to be their professional principles. You mentioned the line prosecutors who had withdrawn from a case. You mentioned the career prosecutor who had left a particular assignment. You had a little bit of experience with this in the DEA. Can you talk about this?
I can. First, let me just say, Mark, there are always collisions, right? I mean, there are plenty of disagreements and arguments in the Department of Justice. And, you know, I've seen some heated conversations about what we ought to do. But those were always sort of devolved to tactics and strategy. It was never about whether or not we should intervene on someone's behalf for political reasons. So there are always disagreements. I imagine you occasionally have them in academia. That's not the problem. The problem becomes when you are asked to do something that you simply can't do for ethical, legal, moral reasons. And so I believe you're referring to a speech that the President of the United States gave in, I believe, July of 2017 in Suffolk County, New York. And speaking to a group of police officers, President Trump condoned police violence. He said he was joking. Don't see that man to have much of a sense of humor. And what he was telling the officers was not to be so gentle with suspects when you put them into police cars. And he essentially said, you know, take your hand off their head. Why are we being so gentle? You know, in my view, condoning police violence. Unacceptable, just simply unacceptable. We have an ethical, legal, and moral obligation to people in our custody to take care of them. We may not approve of what they've done. Logically, we don't if we're arresting them for something, but we have an ethical, legal, and moral obligation to ensure their health, their safety, their welfare, and that they get all of their due process and civil rights. And so I wrote an email to my entire workforce. I really agonized about this because the last thing you want to do as the head of an organization is drag your organization into some political debate, right? When I ran the DEA, I wasn't even technically a political appointee. I was in a career slot running the DEA. So at that point in time, you know, the 13 or 14,000 men and women of the DEA were all career civil servants, including me, even though I was in charge of it. But you don't want to drag them into a political debate. That's dangerous. You want to keep them out of that. And if there's flack, you want to absorb it yourself. But I felt so strongly about what the president said. I wrote an email to my entire workforce and I agonized about it. After I hit send, I felt better, except about 3 milliseconds later, someone had given it to the Wall Street Journal and the New York Times. They actually ended up writing very, very complimentary editorials about the stance we took. And I reminded my workforce that we have that special obligation I described to you earlier, Mark, to care for those people in our custody and a set of core values to which we adhere. I resigned from the Department of Justice and from the DEA shortly thereafter. I don't want to make a big deal out of that, but I could not work in an administration that took lightly our obligation to care for those in our custody. Can't do it. And you're right, there's a tension. There's always a tension between staying because you think you're doing something worthwhile and you're making a difference and you're trying to fix stuff, and leaving when you can no longer abide what the leadership is saying. And you cannot resign every time you have a disagreement. But this was more than that. This was a fundamental break from our core values. And I felt that strongly that I had to say something. So, by the way, no regrets. You know, I've often been asked, why don't other people resign or speak out? And I do want to add this note. It's a highly personal decision. Everybody has to decide where that line is for them internally. Some people are staying and continuing to do good and important work on behalf of the country. Thank goodness for them. And some people have walked away because they could no longer abide what the president was saying and doing. And thank goodness for them too. And others just have to make their own internal calculation about what it is they want to do. I do not pretend that I can give advice to anybody about where that line is for them and what side of it they're on and how they ought to behave.
But I do think it is important to underscore the fact that in your case, there really was a basic principle involved. At least I always have thought that the ways in which we treat those who are accused of crimes and in fact, the way that we treat those who have been convicted of crimes, to a large extent defines what it means to be an American, because the protections that we are expected to afford to them aren't always easy to extend.
That's right. And I'm going to mangle the history here, and I do it with some degree of trepidation talking to a university forum, but I think it was Hubert Humphrey who talked about how we care for those in the dawn of life, the twilight of life, and in the shadows of life. And so, maybe you're referring to folks here, Mark, in the shadows of life. Again, we don't approve of what they did. We have laws that they violated. They ought to be held to account and punished in some way, but we have to take care of them. They are still our obligation. And oh, by the way, an overwhelming percentage of people, I don't know the precise number, but I'm guessing it's in the 99% range of those who are incarcerated return to our streets. And we hope that when they do, that they are functioning citizens, that they have jobs, they pay taxes, they take care of their friends and family, that they participate in society in some constructive way. And so the way we treat them on the way in may have some bearing on how they behave on the way out. And so if you just want to be Machiavellian about it, we ought to take care of them on the way in. But I think it's much deeper than that. I think we have an absolute, as I said earlier, moral, legal, and ethical obligation to those we arrest. Don't have to approve of their conduct, but we have to ensure that all of their rights are met. And I saw the president talking and acting in a way that completely contravened those values that I care about.
Well, how we deal with the return to normal life of those who have been convicted might be the subject for an entire discussion between us. And I'd like to take this discussion toward its conclusion by asking you a non-leading question, if I can remember my evidence and trial advocacy. Mr. Rosenberg, what, if anything, memorable happened to you on the very first morning of your service in the Justice Department?
Yeah, I think technically a non-leading question, Mark, but leading questions are fine, by the way, on cross-examination. So we will permit it, and I will answer your question. So I'm a brand new baby attorney in the Attorney General's Honors Program. This is October of 1990. And the Attorney General of the United States is a fellow you've heard of named Dick Thornburgh. Now, I was a classmate of his son, David, at Harvard. And David, to this day, remains a very, very dear friend. And David knew I was going to the Department of Justice, and he said he was going to let his dad know. And I didn't think twice about it because his father, of course, is the Attorney General. And that's a big deal. And I'm, the newest of the new, the greenest of the green. I'm not sure if it was my first day or my second day, but it was my first phone call. I remember that. My phone rang at my desk. I picked it up. I said hello, and the voice on the other end said, "Hey, Chuck, it's Dick Thornburgh." I immediately dropped my voice to a whisper because I had two office mates. I said, "Oh, hi, Mr. Thornburgh." And he goes, "You're whispering because you don't want anyone to know the old man's on the line, right?" And I said, no, not at all, although that was exactly right. He said, "Why don't you come on up and say hello?" Now, I had no idea how this thing worked, but I went upstairs to say hello. I went to the Attorney General's suite, this magnificent suite on the 5th floor of the Department of Justice. There's about three layers that you have to get through before you get to the Attorney General's actual inner sanctum. And I told the very nice lady at the first desk that I was, my name is Chuck Rosenberg. This is my second day at the Department of Justice. And the Attorney General called me to invite me up to say hello. And she looked at me like I was out of my mind. I mean, that literally some insane person had, snuck into the Department of Justice off the streets of Washington and was now claiming that he had received a call from the Attorney General who wants him to come up and say hello. And I could see her reach under her desk to hit the panic button. And just seconds later, these FBI agents kind of emerged from different parts of the office. Thank goodness Mr. Thornburgh kind of burst out of his office and saw me all the way down the hall and said, "Oh, hey, Chuck, oh, I'm so glad you stopped by." The FBI agent stepped back. The lady who was scowling at me smiled, and Dick Thornburgh ushered me into his office to welcome me to the Department of Justice. I don't think that happens for every brand new attorney. It was an honor to be working for Dick Thornburgh at the Department of Justice. And that's how my career started. First one.
What a way to start your career. And I think about all of the positions that you have held and all of the very accomplished leaders with whom you have been associated over the years. Are there, in your experience, human qualities that contribute to the strength of a person as a leader?
Oh, absolutely. And you're right. I mean, I worked for Bob Mueller and for Jim Comey and Sally Yates and John Ashcroft, Republicans and Democrats, but all the thing they had in common, Mark, they were terrific leaders. So there are these pairs of what appear to be mutually exclusive traits that you find in great leaders. For instance, toughness and kindness. Great leaders are often both tough and kind. I think of Bob Mueller when I think of tough, and I also think of Bob Mueller when I think of kind. And he was able to be both, right? And he was able to be both all of the time. So always civil, always polite, always dignified. But when difficult decisions had to be made or when discipline had to be meted out, right? He could do that too. So tough and kind, I think, is it's a pair of traits that seem mutually exclusive, but you often find residing in great leaders. And there's one other that comes immediately to mind. Again, will seem mutually exclusive, Mark, but humility and confidence, right? How can you be both humble and confident? But great leaders are both. Humility requires the ability to shut up and listen, to acknowledge that there are people in the room around you who may know a lot more about a particular topic than you do, and to actually want and to solicit their advice, right? People who are humble are often great listeners. I saw that trait in President Obama, for instance. Always the smartest guy in the room, but able to just listen. And on the other side of it, confidence, right? So the humility to listen, but the confidence to make that tough decision, to take all of that advice under very difficult circumstances with no precedent and perhaps no guidance from the rule of law or past precedent or other examples. In situations that facts are emerging slowly and often at the beginning incorrectly, and make a decision. So humility and confidence is something you see in great leaders, and toughness and kindness is something that you see in great leaders. There may be one phrase to sum it all up, which is emotional intelligence. Just plain old intelligence is a dime a dozen. You can find lots and lots of smart people. Sure, you can, at the University of Pittsburgh, you can find them all over the place, lots of smart people. But that other quality, that emotional intelligence, that is a gift. And when you find people like that, those are the ones you want in leadership positions.
Well, and I would say that for those who are hungry for exposure to such examples, don't forget that podcast, The Oath, because really that's what you're doing, I think, there is exposing all of us to people who have those qualities and have used those qualities to do remarkable things.
Yeah, the goal there, Mark, thank you for mentioning that. The goal there was to have nonpartisan, apolitical conversations, not about current events, not about the news cycle, but about what shaped these incredible men and women. And so some of our guests have included Bill McRaven, retired 4-star Navy admiral, longest serving SEAL in American history, who led the bin Laden raid. Leon Panetta, the former director of the CIA and the Secretary of Defense. Jim Comey was a guest. Sully Sullenberger, the pilot of famous Flight 1549 that landed in the Hudson River. Kathy Sullivan, the first American woman to walk in space. And Fiona Hill, the Russia expert from the National Security Council. Lots and lots and lots of men and women like that who have served this country, who have served it honorably, who served it well, who took an oath to serve and defend the Constitution of the United States. And again, no politics, We talk about humility, we talk about failure, we talk about mentorship, we talk about second chances, and these folks have incredible stories. So you know what I do? I just stay out of their way and let them talk.
Well, you're very lucky to have attracted such an all-star lineup of guests, and we're very lucky that we've had our own all-star here today, Chucky. It's been really an honor to have you on the program. I want to thank you very much and promise you that when we get through the pandemic, you can come up to Pittsburgh and we'll pull together that ball game we were supposed to have last spring.
You have the most beautiful ballpark in America. I've only seen it from the outside. I'm a huge baseball fan, Mark, so I'm going to hold you to that.
I hope you do. And thank you again, Chuck, very much.
My pleasure. Thank you, Mark, for having me.